Mic check. Microphone. How's that sound? Okay. Thanks. Thanks for coming out this evening. Nice to see your smiling faces, and thanks everyone online. There's apparently a lot of traffic tonight, and so Scott is caught in traffic, but we expect him here any minute. He says he's down Redwood Road somewhere. So I'll just give a few thoughts here on the legislative session that we just dealt with, which is always a nightmare, as you guys are familiar with, right? Few key things. They're after our water right now. They're after all of our property rights. That's communism, right? The abolition of private property. And we see that in the little bits that they move us every year. And right now, the biggest thing that we are really watching, well, there's so many big things, but like water, they're after our water. And they have this philosophy that they're spreading that the state owns all the water. That's how it is in the state of Utah. And if you try to push back to some of your legislators, you'll hear this. We've heard it. We've had other people hear it. And I know they actually tried to pass, they have in law somewhere something to that effect. But the Constitution says that we have the inalienable right to defend and own our property in the Utah Constitution. Okay, it's in Article 1. And so it's important to understand that they're chipping away at these rights, and little by little. So there were a lot of good fighters on all these different categories this session. Chelsea Hope, you guys have heard of her. She's a big one on the water. She does a lot of research on the water. She has a little YouTube channel. And it's kind of, it's a nightmare, right? They're making all these excuses like there's a drought. They're saying we have to save the Great Salt Lake, but it's a big lie because they're actually mining for lithium. So it's really these government-favored corporations that are getting this propaganda in their favor. So the solution to that is us spreading the knowledge of what our rights are and teaching the people how to nullify and claim their rights despite what the law says. Because when the law is in violation of what the Constitution says, which is also the law, then you have the authority, even the duty, to ignore the lower law and uphold the higher law. Our representatives have that same duty as well. So when we see the tyranny happening at every legislative session, we had quarantine laws, we had more digital IDs and driver's licenses, we had all kinds of oppressive taxation. The answer to all of that doesn't have to be beg our legislators to start doing the right thing. It's our knowledge and then getting our local governments to comply, and then us individually and personally to not comply, and so on. And that's what the founders intended. They intended for us to know our rights so that we can stand up against them. But specifically, some other bad bills. HB 405 was this quarantine bill. Quarantine is a word that reminds us of 2020, all the nonsense back then. And during that year, in the special session, there was a bill where they tried to give cities this egregious power. They actually used the words, "The mayors shall have power over your body and your property." What kind of nonsense is that, right? And I remember that was one moment we had a very successful killing of that bill because it came real fast. It was like 11 o'clock at night. We put out a video and it was dead by morning. And I think it just caught them off guard. But they have a longer term game in mind. So this bill, HB 405, came up, and I noticed that exact same language was in the bill. Not only was it in the bill, it was already in law. So somewhere when people weren't paying attention, they just put it in anyway. Again, this time it wasn't the mayors or someone else had the power, but they don't really care where it lands, right? They just inch away at our rights like this. And so my thought on HB 405 was we need to take the opportunity. They're already modifying this part of the law. We need to take that part out. right? And so that was kind of the call to action that we put out at Defending Utah. The other one, another one, HB 184, digital driver's license. There were a lot of activists that fought last year to kill that, the digital driver's license, and they did it successfully. But that was last year. This year, here it is again. There's less commotion, less noticing of it, and so less people making a stink about it, and it passes, right? So we see this pattern. They're going to do what they want to do. Another one, SB 104 and SB 194. This was for the children's safety to require mobile device manufacturers to put spyware essentially on your phone that will identify you. So you can, in Utah, you will no longer be able to buy a device that, if everyone complies with the law, that is not pre-built to identify who you are. You cannot anonymously use your phone online. And so that's like the device side. They're forcing the manufacturers to do that. And then on the social media side, that was SB 194. They're forcing social media to require to know your ID. So they're coming from both sides of that. Now, pushback on SB 104 did successfully change. We require it to, it's optional. Okay, well, but we know what they're going to do next year, right? Or in the next session. They're just going to keep on chipping away at that. They will keep chipping away at our rights forever until we know our rights and we know how to nullify. So that's the magic word, nullification. Okay, so if anyone has not seen our video on nullification, watch that on our YouTube channel. And it is the most important constitutional principle that people need to understand, whether you're in office or you're supporting someone in office or wherever you are. The Constitution dies if somebody doesn't nullify. But when people do nullify, the Constitution thrives. It really comes down to that. But in order to nullify, you have to know the Constitution. You cannot say no to a law if you don't understand why you have the authority to say no to that law. That is why we do this class every month. So we become experts on the Constitution. That's why we have our books and our committee program to fine-tune on that. Okay, so another bill, HB 13. This is a big one. This is huge. Last year, they tried to pass another bill, which failed. And I did a big article on that. I called it micro-regionalism. And if you've seen our other YouTube videos on regionalism, you understand these are shadow governments behind the scenes. And I call it micro-regionalism because they're doing some of the same things. They're erasing borders of our jurisdictions and mixing public-private boundaries and financing. But essentially, that's changing our form of government from a republic to just something else. If you don't know your boundaries, you don't know who the people are. This is logical, right? Think through this logically. If right here is, this little square represents my county, and someone lives here versus here, I know this guy doesn't vote in this county, but this guy does. But if you start saying, well, the borders are somewhere around here, we'll change it when we want, we'll pull in a little bit of this area, and you confuse the borders, you don't know who the people are. You cannot mathematically count who they are. And so that's part of blurring the boundaries. And then if you don't know who the people are, well, then who gets a say in who the representatives are? You've totally lost representative government. Federalist number 39, I believe, Scott can correct me on that, because he probably knows them all, defines Republican government. And it's great that we have the Federalist Papers, because as much as we sometimes wonder, well, how are things supposed to work? What does the Constitution mean? The colonists asked the same questions 200 years ago. They said, why should we adopt this Constitution? So there are these amazing essays where they explained everything. We are not in the dark. We just don't read and understand what they're saying. So this bill to destroy Republican form of government by blurring boundaries didn't pass last year. However, they've been chipping away at it for many years by changing the definitions of districts. So last year, they tried to create this new thing called a dedicated infrastructure district, where they could build amazing, beautiful buildings but somehow separate it from the county and say, well, the county doesn't have to pay for it. It didn't, and that way they could tell people, we're not taxing you, but it's this big, lie about how they do that. This year, if you look up on the website, just the last few articles on HB 13, they passed this, and I really break down and explain how this works. And there's even an example of Governor Cox saying, we're going to build a baseball stadium? But I believe in conservative principles, and we're not going to tax the people to pay for someone else's stadium. But if you read the article, I just unwind it. It's a big lie, and it's because of these special districts that they're not called dedicated infrastructure districts anymore. They just rename them. They call them infrastructure financing districts. So all these creative names for just different ways to violate a Republican form of government. If they want to build a baseball stadium, first of all, the baseball franchise should pay for it. But even if you're going with the traditional, we tax the people socialist style, at least if it's within the city, we can kind of vote to not do it, right? But they're even taking that away. So that's why it's so important to understand the core principles of the Constitution. Hey, Scott, do you want to start setting up your laptop while I just wrap up? Because we want to make sure that the video feed also is functioning well. Thank you. And so I've just given you a sample of the few bills that I broke down this session. And really, it was a fire hose. There were so many, and I was like, I know I could read any one of these bills, and I could probably spend a day like being shocked at what they're trying to do and unwrapping why we shouldn't do it under the Constitution. There were a few good ones. There was a really good one that unfortunately, speak of the bill, this good doctor here approached his representative and said, shouldn't we have informed consent with medical choices? Shouldn't we know that if a doctor is saying, hey, you should, better be careful, this is live on YouTube, what I'm going to say, right? Will I get censored live and my channel shut down? I don't know. So I'm very careful with medical stuff, right? But we can all agree, even YouTube censors, you should have informed consent, right? Choice. And so we try to promote this bill that was like one sentence, maybe two, I don't know, one or two sentences. Very simple, not complicated. Like nobody would disagree with this bill. In fact, in committee, overwhelmingly people came and said, yeah, we love this bill, we want it. The only person that spoke against it, it was the medical lobby. Oh no, this we already give informed consent. This doesn't really happen. So I wrote an article proving that the subject at hand, I won't say it on live YouTube, does actually happen. And the amount of gaslighting that came back, oh, but the bill's dead, it's too late. The bill sat on hold for a month in this committee, and then they said there's not enough support for it. This came from conservative activists that are drinking the Kool-Aid. I was going to say eating their dog food, but it's kind of the same, right? Yeah. Drinking their Kool-Aid. Someone is telling them, oh, there's not enough support for it. Well, the bill already had a vote 2 for, 3 against, and 3 unspoken. That's half and half. Don't tell me that we know there's not enough support for it. Plus, the goal was just get it to the floor. This would be a very popular bill. So that's the kind of nonsense going on. We really need to master the Constitution so that we don't rely on these people to do the right thing. Now, we can spend time asking them to do the right thing. And in a way, it's sort of a due process that we give them. And the committee manual that we have over here on this table talks about a process for learning the Constitution and then spending some time showing whether your representatives will get in line or not. And that's an important part of natural due process. The founders gave that to the British Crown. And it was an important piece of building an understanding in the community of that there's a problem. And so it's not necessarily about we're going to go to our government and then they're going to do the right thing because we said please. But we are giving them an opportunity. And so those are some principles that are broken down in the book. Okay? So yeah, that's kind of my breakdown and my plug that it's good that we fight every legislative session, but if that's all we do, it's a sinking ship. And we need to learn locally how to move. How are we doing on the presentation?
Put the show.
Okay.
Slideshow. Just a second.
Oh yeah, maybe just.
Oh, yeah, just run it. Hit F5. It'll start. It'll just do it automatically. Because PowerPoint's smart.
Smarter
There you
than
go.
me, that's for
Yep.
darn sure.
Yeah, PowerPoint just does it. Great. Okay. So, with that said, we're going to turn time over to Scott, but I just briefly want to say thanks to Food Storage Depot for letting us use this venue month after month. And I do want to acknowledge our Heavenly Father that is the author of our liberties and request his presence when we discuss these sacred liberties that we are here to learn about and learn how to defend. You know, our friends are small. We have like 30 people here online and in person total. And we need a lot more than that to win this battle, because a few of us can talk to our representatives and make a little bit of noise, but we really need a lot of people working in our communities to teach what Scott's teaching us tonight. This knowledge of the Constitution itself, people feel like maybe you already know it. You know I have the freedom of speech. I know I have the right to carry my gun, but that is a small aspect of the whole thing. The whole thing is a beautiful puzzle that just perfectly balances government against the people. And if we don't know how it works and how to use it, then the knowledge is, you know, we can't implement that knowledge. Okay, so anyway, Scott, how you doing? Ready? Okay, so we're going to go ahead and turn the time over to Scott. And thank you.
Oh, it's a microphone.
Put that up as high as you can.
I am. Can I have a little
39?
more?
Yep. Okay, great.
That was 39. It talks about the different representations. Okay.
Make sure your mic's working.
Or my Michael
There you
is
go.
working. Instead of Victor Charlie or Charlie, it was always Charles in some circles. Anyway. We got everything with sound. Hate to sound like a microphone, cell phone thing. Okay, good enough then. Oh, I won't talk about traffic or any of the other things that happened, but at any rate, we're certainly glad to be here. We appreciate our friends in Liberty. What we're speaking about tonight has to do with Article 3, the United States Constitution. We're trying to go through sequentially what that is. The Constitution is basically an outline form. You learned it in 6th grade. You know, Roman numeral 1 is the legislature job description. Roman numeral 2 is the executive, and so on. This is Roman numeral 3. So the judiciary is described here. We're going to talk about Supreme Court tenure. We're going to talk about jurisdiction and exceptions to that. We're going to talk about treason, and the word is used far too loosely today. The founding fathers were very, very careful how they defined that, because the king had a very broad definition for it, and they found that a lot of people lost their heads when they shouldn't have. So we'll talk about that and how it is rarely used appropriately in today's. We're going to use some examples that are real world, real time, and captured a lot of the quote unquote patriot movement in terms of their, am I okay in front of this? Need a little more rope to hang myself, or what are we doing?
The video.
We got HDMI to where we need to. That's a high-tech term that I know, HDMI. It's kind of like, I know karate and 3 other Japanese words. I don't know.
Is this your cord?
No, that one's yours.
Okay, you plugged it in?
It is plugged in. Well,
Okay.
Julia plugged it in.
Yeah, it's plugged in wrong. Just
Live support's gone.
let's
What are we doing?
do.
I recently, while we're offline for a second, I'll tell you, just don't give me any extra time anywhere. A year ago, well, it was actually a couple of years ago this started with, but it implanted in me a filter system that back pressured my blood system, messed up my legs horribly. They're still messed up. But to take that out, it's a long story about how we came to that. You tell me when I'm ready to go again. Okay, not yet. I can tell stories then. Anyway, so finally, after they finally admitted that they had done what they did, that took them over a year to admit it. And I never found out they did it until they got a $28,000 bill. But finally, oh, we did do that. Okay, well, yeah, we got to get that filter out of you. And so I'm really truncating the whole story. It's right here. But so they said, we got to get you in, and we're going to open your carotid, and then we're going to go down through past your heart and lungs and into your abdomen, and then we're going to pull this filter out. I said, man, that sounds rather invasive. And they said, yeah, it is. I says, I always heard you cut your carotid and you're toast. They said, well, if you don't know what you're doing, you are. And I said, do you guys know what you're doing? They said, certainly. So anyway, sometimes when they disconnect life support, it's really concerning to me now. But at any rate, we got through that without, is that an F5 or something like that? I don't know. There we go. All right. Enough stories for right now. If I get another opportunity, I'll regale you with other stories. At any rate, we're going to be speaking tonight about Supreme Court tenure, jurisdictions and exceptions, treason and what it is and why it isn't what they say it is nowadays. It's very limited in its definition. And we're going to talk about some jury and court-related things that were protected further. And we're going to give some examples about, in spite of the fact they went to great lengths to protect some of these things in a judicial kind of environment, we have gone way off the rails in so many things right now. And we'll talk about what some of the founding fathers felt about, shall we say, the authority of the Supreme Court. It's not supreme in all things, and we'll talk about that. At any rate, so those are the paths we're going to try and follow in the time that we have remaining. And I'm sure glad that Enoch was able to review some of the things in the Utah legislature at the time, because that's always a vexing time to me. It's a very, very high-stress time. It's kind of like the lame duck sessions that we get after the November election until the new Congress is seated in the first week in January. And those guys that are no longer going to be there take full advantage of that to load up the goodie box for themselves and other people. At any rate, let's start with Article 3, Section 1. That's the very beginning of Article 3. Okay, so this defines the judicial power of the United States. Now, by the way, you need to understand that under the Articles of Confederation, we not only did not have an executive, so to speak, we only had one branch of government, if you will, and that was the Congress. We had a president of Congress, and so people argue with me, well, we've had several presidents before Washington. And I say, okay. I understand where you're going with this, but you don't understand the new system that was established is so much better than the old Articles of Confederation. So we didn't have a president of the country under the Articles. We did not even have a Congress. Oh, excuse me, we had a Congress, such as it was, but we didn't have a judicial system. So they were defining some new departments or branches of government when they wrote this new Constitution. And you'll find that they actually they read what they wrote and they tied them together and interrelated them. So they were establishing a judicial power. By the way, what it was under the Articles was Congress would appoint a committee to examine issues that might be adjudicated, okay? It was a real clumsy process. At any rate, so the judicial power, which was being established in the United States, shall be vested in one Supreme Court. Okay, so constitutionally it comes into existence. and such inferior courts as the Congress may from time to time ordain and establish. Okay, we're going to find out how that fits into this in a minute. The judges, both of the Supreme and inferior court, shall hold their offices during good behavior. Okay, now, everybody says life, and in fact, you're going to find Jefferson, in one of the quotations I use, talks about their life sentence, and they should get life sentences, oftentimes many of them, but it is not for life. It's during good behavior. And we need to understand that. This is not a foregone conclusion. These guys can see no evil, do no evil, speak no evil. And we know oftentimes they err greatly. So, during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. The reason for that was, if you control a man's subsistence, you control the man. And in two articles, Federalist Papers, Hamilton wrote about that. He talked about if you control compensation, or a man's tools if he's a mechanic, or a farmer's field if he's a farmer, if you control their means of sustaining themselves and their families, you can control. I mean, if somebody gets really hungry and their kids are hungry, they're going to say, just tell me what I got to do. I'll do it. Just make it. So they didn't want that to happen with the judges. They didn't want the legislature to say, those turkeys have voted against some things we've done, and you know what? We'll teach them. We're going to put them on bread and water. Okay, whatever. So these kinds of things were thought through very well. They saw these leverages that were out there, said, we're not going to let it happen in our country. So it's one Supreme Court and the inferior courts that's established through congressional power. And I say, see here Article 1, Section 8, Clause 9. So here that is. Congress shall have power to constitute tribunals inferior to the Supreme Court. This is an interesting check and balance. This is violated horridly right now. Well, Congress still does that, don't they? Who appoints the FISA court judges? It's our Chief Justice, John Roberts. Now, wait a minute. Where does it say those judges can appoint judges to be judges? It doesn't. And so the whole FISA court premise from the very get-go is unconstitutional. And most people go, what's a FISA court? We won't take the time right now to do that. It is an egregious court that has been created back in 1978. And you think of the FISA 702 section and all that. Man, I wish we had time to talk about it. I'm way short on time as it is anyway. But it's F, as in Foxtrot. Okay, so FISA courts are a kind of a secret court, if you will, that issues, don't get me off on a shiny object, but I'll just momentarily pause. They're a court that can say that we can have secret warrants issued to watch Americans and basically capture and build dossiers on Americans, okay? And I haven't looked at their list now, but let's just take a for instance. If they've issued 30,000 warrants to do that in the last number of years, maybe 10 or 12 of them were denied. I have a rubber stamp in my desk with my address on it. It fails more often than that. If I stamp it 30,000 times, I'm going to have more than 12 failures. Can you say rubber stamp? Can you say kangaroo court? And this is what has happened, where they've created a court that looks at these kinds of things in this 702 section that they keep bringing up and saying, oh, we got to have it, or we're all going to be dead because the bad guys are going to win. And basically it allows spying on Americans and building dossiers. And it should be completely eliminated. And right now the Congress is looking at permanently putting it in. Right now they have to reauthorize it every period of time. But in the coming weeks, I would presume, they will slip the FISA 702 section and make it a permanent kind of status in the law. So anyway, like I say, don't get me distracted. But these are all simple things, and I wish there were time to dig deeply on all of them, because we have more problems than we could possibly imagine. But Congress they appoint the inferior courts, not Judge Roberts, not according to the Constitution anyway, but the FISA court has something different. So again, judges hold their office during good behavior, not life. It's an assumed thing that they all there can do no wrong and everything's a be. But you'll see there's been a few, very few cases in the entire history of the United States. One Supreme Court justice in our entire history, a guy by the name of Samuel Chase, was impeached. What's an impeachment? That doesn't mean he was removed from office. It means he was charged or indicted and he was acquitted. Not many of you are in the room here remember 1969, but Abe Fortas was looking like he was going to be impeached. Abe Fortas, I wish there was time to tell you about this scoundrel. He started back in 1948 helping LBJ steal the Senate race that he was in Texas in 1948. He and LBJ were good buddies from then forward. There's a whole history of things. He was appointed ultimately to be Supreme Court Justice. He continued to sit in the president's Oval Office very often and being his attorney and counseling with him. Kind of a conflict of interest. He also took funds from other sources to, some of the, one, for example, was $20,000. You might remember, no, you don't remember, 1969, $20,000 a year was a lot of money. Yeah, for me, it's a lot of money anyway right now, but that's neither here nor there. Fortas was under examination, and it looked like he was going to be impeached and removed from office. Douglas was also egregiously considered at that time. And I believe what happened is they negotiated a settlement. They said, we're going to give you Fortas if you'll back off on Douglas. And that's what happened. But Fortas resigned rather than be impeached and removed. But he probably would have been, in that political environment, probably would have been found guilty and removed from office. But anyway, that's a Fortas thing. There were 14 other federal judges that have been impeached. And again, that's charges. That isn't removed. And they had everything from drunkenness on the bench to bribes, but 8 were convicted, 3 were acquitted, and 3 resigned. They said, it's getting too hot in the kitchen, I'm going to leave. Okay. This is used far too rarely. Far too rarely. It's a scarecrow, as Thomas Jefferson used to call it, this impeachment stuff. But that is still open as an option to remove judges, any of these judges that are appointed. Okay, so going on. In Article 3, Section 2, Clause 1, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made under the authority to all cases affecting ambassadors, other public ministers, and consuls, and to other cases of admiralty and maritime jurisdiction. This one could take a lot of time to unpack. However, it's interesting to me, a lot of people think that all federal law arises under the Constitution. You see that on the second line halfway through it. Power to extend to all cases arising under this Constitution. Here's the problem. Most of the laws that are created today are not found in compliance to the Constitution. But I had a very long conversation here a couple of weeks ago with somebody back in the Midwest that was absolutely determined that all things that happen are under the Constitution, and it's not correct. The Constitution is violated unceasingly and unsparingly. But all of us, not all of us, but many of us seem to have the impression that if a federal law is made, let's just take the Violence Against Women's Act back in the 1990s. Biden and Hatch were chief sponsors of that. This is when Biden was assaulting Tara Reid, one of his interns, in the hallways of Congress, and he had a bill before Congress about violence against women. I'm not advocating violence against women. It's a horrid thing, but it's not a federal offense. But they were making all these things federal, and it's unconstitutional. So just because something's horrid does not mean you can make a federal law, and now it's at a higher level of horribleness. It's horrid regardless, inherently and by definition. But these people think they got to make a law about everything. Just like Joe Biden on his State of the Union prep rally that he held last night. Debacle. We're going to get a study going on women's health with Jill Biden managing that. How did we get Jill in this? How are we starting a new program? What's going on, kids? Okay, anyway, fact of the matter is women's health, men's health, anybody's health has nothing to do with the Constitution, okay? But he's starting a new federal program that Jill is going to oversee, and it's kind of like probably what Bill had Hillary do back in his administration about health care, and it'll be metastasized equally bad as that did. But yes, sir. They keep putting their wives over things, and it's kind of like you get a package deal when you elect anybody, you know, and it's like, no, we don't have a package deal. This is not bringing monarchy into this where you have inherited, you know, status. Yeah, it's everything's a disaster. No federal fingers in anything. Okay, going on with clause 2. This is the jurisdiction of the court, okay? They have oversight of controversies to which the United States shall be a party, to controversies between 2 or more states. Okay, now, then you see this part that's in a light blue and in brackets that says between a state and citizens of another state with an asterisk by it. And then it goes on to say between citizens of different states, and then it goes on to say between citizens of the same state claiming, and then claiming lands under the grants of different states. Now, there was still arguments about where the western states ended on the eastern seaboard, and so there was arguments there. And then there's some others in brackets here in a darker blue that says between a state or the citizens thereof and foreign states, citizens or subjects. Both of those that are in brackets have asterisks, and this was changed by the 11th Amendment. We get the first 10 amendments, Bill of Rights, and then boom, 11th Amendment pops up because we had citizens from one state suing another state. So if you lived in Georgia and were mad at the state of Carolina, one of the Carolinas, you went to the Supreme Court. They said, we ain't going to have this. They did not want the states to be going on bended knee before the Supreme Court every time somebody brought a lawsuit. So that 11th Amendment, which says, reading in the fine print, if you can maybe read it on the screen, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Now, if you got my book, I discussed this at length, how they were very careful to make sure the states were not in any way subservient and going on bended knee before the general government. And this was one thing that they felt, oops, we screwed this up. And they took the approach that Washington suggested in his farewell address, that if there's something wrong with the Constitution, change it by amendment in the way it's defined in the Constitution. And they did, and that's how we got the 11th Amendment. Okay, so basically Section 2 enumerates cases in which the federal court exercises what they would call original jurisdiction. But then we go on to Clause 2, and I'm not going to take the time to read all this in detail. You guys got constitutions, I hope and pray. But the last little half of a sentence that's in Article 3, Section 2, Clause 2, it says, with such exceptions and under such regulations as the Congress shall make. Okay, so the first part of Section 2 defines the organic authority of the United States Supreme Court. It says, here's the cases, automatically they come before the Supreme Court. And we're going to see here in a little while an approach that could have been used after the 2020 election that should have been used and wasn't used. And the Supreme Court abrogated a responsibility. But there's this little clause that says, okay, other things can be appealed to the Supreme Court with, that's in this bolded and underlined part, exceptions that Congress sets. And we're going to look at that here momentarily. Okay, so if they didn't have something mentioned in the clause as organic authority of the Supreme Court, you could appeal to it. But Congress can say, except, see, if it's not officially identified, there can appeal. But you can say, no, it's not officially identified, And you can't take these on as cases either. You can do that. We'll talk about that. Yes, sir.
When you say organic authority, you mean original jurisdiction?
They take original jurisdiction, lawsuits between states. Where would you take that? I'm going to go to Salt Lake and take that on. If I'm from Utah and I'm suing Colorado. No, Colorado's going to say the heck with you. We're going to Colorado. No, it goes to the Supreme Court. That's how they got it set up. There's an understanding where you have a clear recognition that there could be biases. You take it somewhere else. Okay, so yes, that's exactly what this Article 3, Section 2, first clause does. It defines those cases that automatically go to the Supreme Court. Okay, so I have written for your edification and enjoyment. I'm sure each one of you will be, oh, this is wonderful. Anyway, I put together a generic congressional act which could remove cases from the jurisdiction of the federal courts. I would not assume that every case and every law that they create would have this attached to it. But here's an idea, and it's pretty simple. It's just a paragraph long. And this is what Congress would pass with their whatever they were going to try and block from the Supreme Court. Like, for example, marriage. What the heck does the general government have to do dinking around with that? And especially once they've got their fingerprints on some of this stuff lately, you're going, people can love who they want, but that doesn't mean the general government has to jurisdiction over it. So, okay, so marriage or maybe killing babies, okay? You could say, we're making a law about this and we're going to keep the Supreme Court with their grubby little mitts off of it. So you can put whatever subject you want where I give you the opportunity to. It says the appellate jurisdiction of the Supreme Court and the jurisdictions of the inferior federal court shall not extend to hearing or determining the power of a state to, that's when you put your subject in, such jurisdictions shall not extend to hearing nor determining the refusal of any state to give full faith and credit to any act regarding, put your issue in there again, whether it's abortion or marriage or whatever, under the law of any other state. And the reason you have to put that in is because Article 4 addresses this issue. See, this issue says, we're going to, and when we get to Article 4, which at the rate I'm going tonight, I'm not sure it'll be next time, but that's coming up, Article 4 is, and we give the full faith and credit to other actions of other states. And so we exclude that, and we say if we did something like marriage, that you can't dink around with saying how we got to have marriage in our state, you're not going to be able to sue me from another state because I don't do it the way you want to do it. Okay, so that's kind of the way that is. It's a generic act, and think about it if you wish. There's an example I call the McCardle case. This is a guy, this came from some incredibly horrific times in the United States. Came during the Reconstruction, I call it the deconstruction period, right after the Civil War. Almost that way, but it was worse, I think. Anyway, but here's what the problem is. We have many patriots, so-called today, that want to have the military take over jurisdiction of courts, and they want them to rule in tribunals. That's what we had in the deconstruction period. It was horrific, bad, evil, nasty. It was an occupied territory at that time. And there is a big movement in the nation today to have that happen. But I will tell you, the military, having served and having had many, many interactions across a broad spectrum of military personnel, the cross-section of America, where half the country hates the other half, is exactly what it is in the military. You're going to find flaming communists out there. You're going to find Attila the Huns out there, okay? And everything in between, if you will. They're both bad, by the way. But so what these people that want to go with a military tribunal on everything are going to find that their tyranny is worse than whatever the worst they can think they're having right now. We can't go there. But here's an example out of the post-Civil War era, 1867, 68. And that was a little before my time even. But the fact of the matter is, this guy, William McCardle, was a newspaper publisher, and he wrote what they called incendiary articles, which was in opposition to these deconstruction laws that the radical Republicans were passing in Congress. So they said, you ain't going to do that. First Amendment stuff, forget it. Of course, Lincoln had done an awful lot of that before. Lincoln had jailed hundreds of newspaper editors and owners about stuff like this. He shut down legislatures too. It's kind of like, Declaration of Independence, pre-Declaration of Independence stuff that the king had done. Okay, so McCardle was arrested because of this. He was jailed, a military commander, these tribunal things, Military Reconstruction Act of 1867. United States Congress had passed it. He invoked habeas corpus, like bring the body before the court and justify why I'm in jail, okay? He was in Mississippi, so this boy was a Southern boy, okay? I was stationed down there for quite a time. Wow. It was, Keesler. Yeah. The judge sent him back into custody, saying the military actions were legal under Congress's law of 1867. So he appealed to the Supreme Court because there had been also a habeas corpus law that Congress had passed in 1867. So he was saying to the Supreme Court, please look at this, whether I should be jailed or not. Well, it was argued, but before an opinion was delivered, Congress suspended the Supreme Court's jurisdiction in the case, okay? So they said, okay, under Article 3, Section 2, Clause 2, you guys don't have any power to look at this case. So did the Supreme Court have jurisdiction to hear the case? And if so, did his imprisonment violate his Fifth Amendment due process? Okay, not to say anything about the First Amendment right at this point. That wasn't in the argument. There was a guy by the name of Chief Justice Chase that wrote for an anonymous court, unanimous, not anonymous. They should be anonymous, maybe. At any rate, they said, oh, Congress is right in withdrawing the court's jurisdiction. And the Congress could. This was an abominable case, an abominable, egregious violation of a man's rights, and it was also constitutional. So it was kind of like when Andy Jackson was ruled against by the Supreme Court about some of his actions against the Native Americans. And what happened was the Supreme Court ruled against him, says you can't do that. And Eddie Jackson says, oh, they have their ruling, now let them enforce it. There's no enforcement arm on the Supreme Court, okay? So he says, I don't care what they wrote. Well, that's kind of what was happening here. Abominable things, but people were keeping that constitutional arm's length kind of thing between the departments. So what happened was this exceptions clause in Article 3, Section 2, Clause 2, was they could write exceptions. Okay, so we're going on with this case. This is, again, the Supreme Court Chief Justice. He said the 1868 statute repealing the jurisdiction does not affect the jurisdiction which was previously exercised, but the court held it didn't have jurisdiction to hear the case, so they didn't answer the question. Congress withdrew the jurisdiction to hear the case. McCardle had no legal recourse to challenge his imprisonment in the federal court. So it was an injustice, piled on an injustice. I'm not suggesting we do things that way. What I'm saying is that the courts can be blocked, and we should do that more often. But here's basically a recap. It happened during Reconstruction. So the Congress says you can't rule on the case, and prohibited the Supreme Court from doing so. So here's what the Supreme Court wrote. We are not at liberty to inquire into the motives of the legislature. We can only examine into its power under the Constitution. The power to make exceptions to the appellate jurisdiction of this court is given by express words. Again, Article 3, Section 2, Clause 2. It is quite clear, therefore, that this court cannot proceed to pronounce judgment in this case, for it has no longer jurisdiction of the appeal, and judicial duty is not less fitly performed by declining ungranted jurisdiction than in exercising firmly that which the Constitution and the laws confirm. So it was a sound constitutional decision, but a U.S. Congress was usurping and violating and became a tyranny. The radical Republicans truly were elected tyrants in the United States during that time. There might be analogies today that could be drawn. I think the Republicans are too. I'm sorry. I really do. I think you're right about the Democrats, but I think they're an overwhelming of the Republicans do not understand the limits and bounds constitutionally. So we go back to this with at the bottom couple of lines, with such exceptions and under such regulations as Congress shall make. Congress can block Supreme Court things that are not on their original jurisdiction list. So we have to go back and say, oh yeah, they're going to rule on this and this and this. Oh, this is one that's not on the list. We can accept that. Okay. Okay, so we go on to Article 3, Section 2, Clause 3. The trial of all crimes, except in cases of impeachment. Huh? Why? We'll see that in a minute. Shall be by jury. Does everybody get a jury trial? No, they don't. And such trials shall be held in the state where the said crime shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. So, you know, it's something on the high seas or something, or in a territory, then there's going to have to be another place chosen. So, trial by jury's protected, except in cases of impeachment. We'll look at that. Why not impeachments? Well, let's go back in Article 1, Section 3, Clause 6. So we have to go back to the job description of the legislature. The first article in the Constitution, okay? So Article 1, Section 3, Clause 6 states, the Senate shall have the sole power to try all impeachments, okay? The Senate tries them. The Senate is that's the court that it happens in, okay? When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside. So we've talked about before about why it isn't, you know, normally the President of the Senate is the Vice President, right? Okay. So why isn't the Vice President in charge when there's an impeachment of a president? Could be one of two reasons. One is the Vice President's rubbing his hands and licking his chops saying, we get this turkey out of there. I'm going to be president. Like Kamala Harris may be doing at some point if there's some kind of Amendment 25 thing invoked. At any rate, we'll take that path some other time. And we don't want the Vice President to be in there in charge of it when they might be totally in the camp of the President trying to skew the outcome in favor of the President. So they didn't want the Vice President sitting there, and so they put the Chief Justice in charge. No person shall be convicted without the concurrence of 2/3 of the members present. So if the Senate makes the trial, you have to have 67 senators, if everybody's there, say, yep, guilty, then they remove them from office. Okay, so that's why we don't do a jury trial on impeachment, because we have another process that has to go through. So some people, when they were ratifying the Constitution, you know, after it came out in September of 1787 and was sent to Congress, then sent out to the states, it got ratified technically by 9 states, which was the threshold by July of 1788. But there was a lot of debate and discussion. You know, the Anti-Federalists got involved, and we won't discuss that at all. But the Anti-Federalists, I think, were wise in a lot of things. And so I'm glad they wanted a Bill of Rights, okay? But some of those guys thought that, including Thomas Jefferson, he said, I don't think you've protected well enough some of the things in the jury trial and others court things. So they said, no, we don't want this unless you get a Bill of Rights. Well, the issue was finally addressed in the Bill of Rights. September 26th, if I recall, of 1789, they sent out 12 proposed amendments to the states that were to become a Bill of Rights if they were ratified. December 15th of 1791, 10 of them were ratified. One of them got ratified 200 years later. The other one's still out there floating around. At any rate, if it gets ratified, we're going to have a really big Congress. There's pros and cons of that too, but we won't discuss them tonight. Okay, so in the Bill of Rights, there was a preamble, just like a preamble to the United States Constitution, and it said that they were trying to prevent misconstruction or abuse of the powers found in the Constitution, and so they added further declaratory and restrictive clauses. So they're saying these are more constraints on the general government that they wanted to bring forth. Okay, so Amendment 5, we're going to look at some of these right now, and I don't, someday, maybe if we continue on this and you guys are interested, we'll do a Bill of Rights. You know, we'll probably take several sessions. Second Amendment could take multiple sessions. I don't know. But at any rate, we're just touched basically on the fact that in the Fifth Amendment, they said a grand jury needs to be able to look at things before somebody gets charged. Now, a grand jury was supposed to do this off the record, not off the records technically, but off the public eye. They weren't supposed to be there, because if you get charged, or not charged, at least somebody's accusing you of a crime, it's a really crappy, hard, difficult, life-disrupting thing to get charged. And so a grand jury was supposed to be able to look at the material that was out there and say, you know what, there's smoke, there's fire, maybe this person's guilty, we'll charge them. But if there was not enough, the grand jury would bring back a no bill and they'd say, nope, we don't have enough to think this person should be charged. And that would prevent that person from having to go through all of the gyrations of protecting themselves, having their good name dragged through the newspapers, and on and on and on. So that was a protection of the accused. And in fact, what you'll find if you look carefully on the original intent of the American Founding Fathers, you'll find that they, in every way possible, tried to protect the ones that would have been charged. So I'm not saying they were trying to protect guilty persons, but they wanted to make sure that there was not some kind of travesty of injustice that happened where an innocent person was charged, convicted, and the conviction was carried out. They really built a barrier as much as they could to protect that person's interests. And in fact, they were willing, I believe, to sometimes say, we'd rather have somebody that was guilty get off instead of somebody that was innocent be punished. Okay. It's not in that way today. You're absolutely correct. There is not. Today, it's balanced the other way, or biased the other way. And it's really bad. So anyway, just looking at a couple of times, you're not going to be put twice in jeopardy, and you don't witness against yourself. You get due process, and private property is not going to be taken without just compensation. That's the Fifth Amendment. We'll talk more about those when we get in the Bill of Rights, if we get that far along this pipe. So, grand jury, no double jeopardy for the same offense, constantly being violated. A state law versus a federal law, and they charge you twice for exactly the same crime. It's they say, oh, no, it's a different crime on federal books. Anyway, sometimes my head gets a tick, when I think about these things. Okay, you can't do self-incrimination. You get due process if you're going to take person's life, liberty, or property. And you got to pay for private property taken. Now, I'm going to spend some time on this because this story is a tragic story, actually, that actually shows how far we have fallen from this plain, simple truth. And nowadays it's being spun in a different way and went clear to the Supreme Court, and the Supreme Court went along with it. So we'll just look at this. No person deprived of life, liberty, property without due process. That's part of the Fifth Amendment. And you can't take it without just compensation. So we're going to look at you might say I'm taking too much time on this Kelo case. But think about it. It's how we have spun our justice system in spite of our Bill of Rights. Okay, this was decided by the Supreme Court. And what it was a transfer of land, eminent domain. They were seizing land from a bunch of private owners, actually. But the one private owner named Kelo was the central name on the case, to another private owner for economic development. Now, think about this while we're going through this. Let's just say the state says, you know what? We got a developer here that says they can develop this beautiful beachfront property, and they can bring in, through resorts or whatever, great tax, into our community. And man, we're all going to be better off. We're all going to be rich, 2 cars in every garage, chicken in every pot, all that kind of stuff. But it was a private owner for another private owner. And they're going to use this eminent domain thing they're saying we can seize property for the good of the community. Now, who pays 0 taxes? Churches. Okay. So if you want to look at a worst case scenario, say we could take all these churches out here and by golly, we'd be able to put them under a tax structure. We'd all be better off. Everybody in favor? Okay. So that's the kind of the worst case scenario. And then we're going to see in this case too, and I hope I can just skip across it and you can read real fast when we go through here because we're fast running out of time. But normally, underprivileged individuals, let's say they're socioeconomically deprived, not depraved, okay, I didn't say that. So they're socioeconomically underprivileged within a society. Normally, those people do not exercise their property in the most beneficial way for the state or the community. You know, you may be somebody that's just glad to have a home over your head, and you're not putting out a little storefront there and collecting taxes for people that come by and buy your groceries there, you know. So it adversely affects, certainly churches, it would adversely affect individuals of some of those different, more depressed, if you will, socioeconomic statuses. So it's a, as you're going to see in here, the Supreme Court says, no, this is a reverse Robin Hood syndrome. We're stealing from the poor and giving to the rich. What are you talking about? This does not have a happy ending in anybody's case. Okay, so they did a 5-4 decision. They says, yeah, you can do economic growth stuff. You can do private development. And it's okay under the takings clause. Okay, what? What are you talking about? Okay, so privately owned real estate in New London, Connecticut, condemned for extensive or comprehensive redevelopment. Okay, they were going to allow the private developer to develop and proceed with the plans. You're going to see this private developer had a real sweetheart deal. I mean, like if I could take control of beachfront property, like 90 plus acres, and rent it from the city for $1 a year, pretty cool deal, isn't it? Yeah, I might even build a house there. Who knows? Okay, so the court decided this, and they said, you can go ahead as a private developer. The private developer wasn't able to get funds, and as of now, the lots, the section, the land is undeveloped, but we're going to find it even has an unhappier story. Taxpayers in New London, Connecticut got taken for a ride. Okay, so it was appealed to the Supreme Court, and they decided in favor of the city. You can take these people's property, okay? So this Suzette Kelo sued the city in Connecticut courts. They argued that the city had misused its eminent domain power, and it was limited in the takings clause and the due process clause and the 14th Amendment. So all of these things were violated. That's what they appealed it on. So they're saying that if you took it for economic development, it doesn't qualify for this takings clause, okay? And I can see all of this and agree with it. So the Connecticut Supreme Court heard it in December of 2002. They issued a decision in 2004, and they had a 4-3 decision. So here's 7 judges, 4 of them are in favor of seizing the property, 3 said no. What a deal. Okay. So they said it doesn't violate the public use clauses in the state and federal constitutions. So the United States Supreme Court hadn't ruled on this in the 20 years intervening between 1984 and 2004. They'll say, okay, we'll look at this case. So a public purpose and public use, do they mean the same? Okay, so they decided to look at that. Okay, so they could take it for economic benefit, not just to get rid of slums, and I'm opposed to that too. But anyway, we can talk about that at some point, because states have for a long time said if we're going to improve the neighborhood, we can do it for that reason too. Okay, so they decided to look at it for economic purposes. Well, this economic development, even if there wasn't blight, was how they had the law at the time. So the Development Corporation, as we said earlier, was a private entity. So they come in and have this big argument. Okay, they only wanted to repossess so they could generate higher tax revenues. Again, if a church is there, can you seize it? Because anything that goes there is going to get tax revenues. You put a fast food restaurant that's doing greasy burgers, they're going to at least take sales tax, aren't they? And you're going to pay that. So seems logical to me. Let's get it for the government. Okay, so there was a whole bunch of people on both sides of the argument. And there was arguments that politically weak communities with high concentrations of minorities and elderly would be targeted with stuff like this, because they don't have the economic means to either defend themselves or to set up some other valuable thing that the state will be able to tax. So in 2005, they argued it, There were 7 members that listened to it. There was a couple that were missing, Rehnquist and Stevens, that were out of town at the time and recuperating. And so they got to look at the paperwork later. They read the briefs, participated in the decision. Scalia wanted to say, well, look, if you destroy the distinction between public and private use, this is going to be a real blurring, okay? So this benefit to the state was not enough to justify use of condemnation. Just because the state's a little better off with more tax revenue, that's not justification for seizing property. Okay, now remember, this is in light of the takings clause of the Fifth Amendment. This idea of taking property and due process and the idea of fair compensation, all that kind of stuff. We got a Fifth Amendment, and the Supreme Court's looking at this. It was a 5-4 Supreme Court decision in favor of stealing the property. Okay, so Stevens and these other 4 people listed here were in favor, and Stevens said, the court long ago rejected any literal requirement that condemned property be put to use for the general public. So what he's saying, we can take it for this guy over here. It's not a guy. You're going to be interested in the corporation that was doing that. It's a big Soviet style. Yeah, you understand that. Fact of the matter is that the corporation in question was somebody you've heard about in more recent days. A company called Pfizer, which we all have come to know and love. Anyway, they get what they got coming. Karma will come around someday. So it was decided in 2005, and there were 4, O'Connor, Rehnquist, Scalia, and Thomas, that voted against it. The others were in favor of it. So they said, this is a reverse Robin Hood, take from the poor and give to the rich. It'll become the norm. Okay, here's the statement they made. Any property may now be taken for the benefit of another private party, but the fallout from this decision will not be random. The beneficiaries are likely to be those citizens with disproportionate influence and power on the political spectrum, so the rich and famous, including large corporations and development firms, which is exactly where Pfizer was sitting in this whole thing. O'Connor said any distinction between private and public use of property and thereby effectively deletes the words for public use from the takings clause of the Fifth Amendment. Thomas said the differential shift in phraseology enables the court to hold against all common sense that a costly urban renewal project whose stated purpose is a vague promise of new jobs, and that's exactly what they got out of this. We're going to bring jobs into your community. We want to do that. And increase tax revenue, but which is also suspiciously agreeable to the Pfizer Corporation, is not a public use. Okay, Pfizer was at the center of this. Thomas said, something has gone seriously awry with the court's interpretation of the Constitution. Though citizens are safe from the government in their homes, the homes themselves are not safe. This is kind of what happens to us every time the legislature meets, whether it's a water rights thing or whatever. Okay. All right. Thomas pointed out that some of these disproportionately poor communities are going to bear the burden of this. And that's what his quotation on here says. So the city officials, this is not an insult to injury. I mean, it just makes you want to break your heart. They decided they're going to charge back rent since the condemnation procedure started. For 5 years, they've been fighting this. They say, sure, we won. Now you owe us 5 years rent, okay, on the property that you've been occupying while we fought this out. So that's the big problem. Tens of thousands of dollars back rent. Well, the governor intervened, and there was some, deeded property elsewhere that they said they'd move the people to and all that kind of stuff. So injustice was supposed to have been mitigated by that. So there was some New London residents that started a new political party to combat the takings. It was eventually settled when the city paid substantial additional compensation to the homeowners and agreed to move Kilo's home to a new location. Oh, well and good, I'm sure. I think all of the karma guys are going to get caught up on someday. But the land was never deeded to the original homeowners, most of whom had left New London, okay? And 3 years later, the Kilo house was dedicated after being relocated to another place downtown. And she moved, Suzette Kilo moved to another place in Connecticut. Okay, this is kind of giving you a blow by blow. The developer stood to get a 91-acre waterfront tract of land for $1 per year. Couldn't get financing, even with that deal. It's like you got 91 acres, you can develop it but you still ought to have a profitable thing where you can pay the loan back. Couldn't get financing, okay? So the project was abandoned. In 2010, it was a vacant lot, generating no tax revenue. And after Hurricane Irene, it became a dump for storm debris, okay? Tree branches, vegetation. Yeah. Okay, so this is what the San Francisco Chronicle wrote. The well-laid plans of redevelopers, however, did not pan out. The land where Suzette Kilo's little pink house once stood remains undeveloped. The proposed hotel, retail, condo, urban village, can you say smart cities? I don't know, has not been built. And earlier this month, Pfizer Incorporated announced it is closing the $350 million research center in New London. That was the anchor for the New London redevelopment plan. And they're relocating the 1,500 jobs that they promised. Okay, so this is what the New York Times said. They stole our home for economic development, said this homeowner, Michael Cristofaro, and it was all for Pfizer, and now they get up and walk away, okay? Okay, so the final cost of the city and state for the purchase and bulldozing of the formerly held private property was $78 million. The promised 3,100 new jobs and $1.1 million a year in tax revenue had not materialized, and currently the area remains an empty lot. Okay, all of this for tyranny. A lot of states changed their eminent domain laws, and some of them have been superficial, but there are laws. 45 states amended their eminent domain, and some are really cosmetic. New York Times editorial board agreed with the ruling, and so did the Washington Post. Now, surprise, surprise. It's, you pick a subject, any subject, close your eyes, and if it's against what you believe, those guys will be for it. Okay. So, Amendment 6, there's an impartial jury that's got to be there. You've got to be informed of your accusations. If you're accused, this is still protecting your presence in the court. You get to confront witnesses against you. You get to bring witnesses in your favor. In fact, you get the court's power to say to somebody that's a witness, you got to come or we'll arrest you. Okay, because you know what? I don't know if you've ever seen an accident or something like that, and it's like, I don't think I want to give a statement to the police. I mean, I remember one time we watched a head-on collision right in front of us. And when the police were talking to us, it's like, dang, anything I say will be used against me. I mean, I remember saying things like that. I know I'm going to end up in court because of what happened. Both people, they both violated the law. And so anyway, but you get those feelings when you're going to be called to court. You know darn good and well you're going to get called to court. But I don't want to go, but you should go for justice's purposes. And even if people don't want to go, the court can say, you got to go, okay? And you get to have assistance of counsel for your defense. So those are what Amendment 6 brings out. Amendment 7 is another one in civil suits. The right to trial by jury is preserved, and the jury findings can't be questioned, okay? I'm simplifying some of these things. Amendment 8, excessive bail, excessive fines, cruel and unusual punishments. All of these things are hugely, hugely violated today. In fact, sometimes they arrest your property, even if you're never charged with a crime, and they seize the property in a thing called asset forfeiture, and they keep it and they spread it among the arresting agency and other agencies that happen to want to get their fingers in the mix. It's what? Well, sure it is. It works just grandly. And boy, I wish I had time to tell you a story about that, where the Utah Attorney General, I normally don't like petitions and citizen, kinds of efforts that way, but it went on the ballot, and the citizens overwhelmingly opposed this asset forfeiture thing. And the Attorney General, as soon as the election was over, wrote a bill, took it to the Utah legislature, and got it overturned by law in the Utah legislature. Very, very, this idea of excessive fines. You can lose your car for having, if your kid, 16-year-old kid's driving around town in your car, there's a shotgun shell underneath the seat from the last time you were shooting, and they find that, kid can't have it, we can seize your car. Really ridiculous things. Okay, so there's excessive bail, excessive fines, all prohibited, as well as cruel and unusual punishment. I wished we had time to talk about some of the findings under the George W. Bush presidency. where they wrote authorization for everything up to but excluding death. You know, I mean, the horrific things that they said were not cruel and unusual punishment. But that's kind of the way we're running right now. Okay, let's go into this treason thing. Article 3, Section 3, Clause 1. I've capitalized treason because this is an issue that is absolutely on the tip of the tongue of many people today. Treason is bantered about as if it were a jaywalking scenario. Anyway, treason, they define treason very specifically. Shall consist only in levying war against them or adhering to their enemies, giving them aid and comfort. This idea of talking smack on somebody, it doesn't qualify, okay? Anyway, it's become much more broadly interpreted than that. And no person shall be convicted of treason unless on the testimony of two witnesses of the same overt act. So somebody had to see you do the same thing. Two people had to see you do the same thing that qualified under the previous definition, or a confession in open court. So you know how Perry Mason, maybe some of you have never heard of Perry Mason, but it's on late night TV now. He always wins, not always, but very often wins in court, where he's sitting there and he's got some witness on the stand, he's badgering, and the guy says, all right, I did it, but I had good reason. I mean,
frequently somebody from inside the audience would stand up and start
it's
saying,
me.
I'm the one who did it.
Yeah.
He deserved to die. I'm the one who did it.
Okay, so the Perry Mason's a very great dramatization for good theater and everything like that. But that's how dramatic it has to be. You have to have two witnesses of the same act that qualifies under the definition of treason, and then you also could get by with an open court confession. So that's pretty narrowing. Okay, then. Well, that's a problem. It doesn't qualify. It does not qualify treason. No, it doesn't. He would be, okay, the question has to do with, okay, so the president's helping people invade. And you're going to find that the only people that can, if we have a declared war, then you have the enemy thing. If it's not a declared war, you do not. And we'll go over that in some length. Yes, sir? Well, if I don't cover it in the okay, well, we'll talk about that in just moments, I hope, if I get to it. These guys may shut me down before I get to any of this, and we may have to go to another gathering. But I have fun with it anyway, so, you know, I don't care as long as you don't care. But then we'll discuss about this Article 3, Section 3, Clause 2 thing. The Congress shall have power to declare punishment for treason, but no attainder of treason. What the heck is that? We'll talk about that. Shall work corruption of blood. That's not a bad blood transfusion, which I had plenty of them in recent times. Forfeiture except the life of the person attainted. We're going to have to unpack this one a little bit. Here's a few lines that people say, I've never heard these words before. And even if you read them in the Constitution, you may not clearly understand them. Okay, so treason is defined with these three elements: levying war against the United States, adhering to enemies of the United States, giving aid and comfort to U.S. enemies. That's the only three areas that they could fall under. Now, some of us might remember, now I was in the service at the time that this occurred, so I'm not fond of Jane, or Jane Fonda. Anyway, Hanoi Jane was what she was known as, and here she is sitting on a North Vietnamese anti-aircraft gun in Hanoi in 1972. And there's no evidence that she actually fired the weapon against American aircraft or anything like that, but here she is, a photo op, a Kodak moment, whatever you want to call it, sitting there, and there's all sorts of documentation about this, but this is a picture I chose. Okay, so why wasn't she charged with treason? And I've asked myself that many times. But it goes back to the Supreme Court decision. A foreign nation cannot be classified as an enemy until Congress has made a formal declaration of war against it. That's the definition. Mexico has not been declared such. Neither has Nicaragua, nor Venezuela, nor any of these other places. Okay?
Basically can be.
It's illegal to have a Cuban cigar, but it's not treason. Okay. So anyway, so this formal declaration of war has to be the issue. Okay. And in my lifetime, we have not had a formal declaration of war. In fact, the last time we had one was in June of 1942. There was some dribbling in of war, declarations of war against the United States by some friends of Hitler and Mussolini. They declared war against us in June, and we said, all right, we'll declare war against you too. It was a tit for tat reciprocity thing. That's the last time we had a formal declaration of war. Okay, so unless Congress declares a war, reality says there is no authority to have a war.
And why did we have Korea, Vietnam, Grenada, Afghanistan, Iraq, Kuwait?
Not a one of them's constitutional, is it?
Violation of the war.
And the War Powers Act is a violation of the Constitution. Everything we've done in regards to war has violated the Constitution in my entire lifetime.
Why didn't they just not go?
Some didn't go. Cassius Clay, or excuse me, Muhammad Ali didn't go. Well, that's what his mom called him. But he was a magnificent boxer. There's no getting around any of that.
United Nations resolutions,
Right.
and every soldier who took an oath to the Constitution, if they knew the Constitution, had they gone through this boot camp, they'd go, oh, wait, we can't go to war yet because there's no declaration. We'll do our duty. We're just waiting for the congressional declaration.
But
That's why I
Michael-
talk about the knowledge in the Constitution.
So I've got a question. Say somebody's in, let's say, the National Guard. They're saying, hey, we're going to deploy X amount of people to go here to support this. So if they don't go and they get threatened with,
Dishonorable discharge, all that kind of good stuff. You know, there's all of these unlawful orders. I've got a number of presentations I've given to military operations at their request about lawful and unlawful orders. And there is no requirement that you obey an unlawful order. But they come down with a big hammer if your CO says. I personally know, I gave a presentation, well, we're getting off on a shiny object again. Enoch will probably have to extend it. You just tell me when to stop and we'll.
Yeah, try to. If we can, we'll try to hold questions at the end, and then I'll pass the mic around. Everyone online wants to hear the conversation.
Okay, so you're not asking a question. So you're not making a bid right now to buy the thing. So if you move at this moment, anyway, yeah, this whole thing, Michael New, some of you may remember Michael New and his dishonorable discharge. I knew a young captain that I had made a presentation before his military organization, his 06, his bird colonel, absolutely, unequivocally wanted a immediate and unequivocal do or die response, anything he told you to do. And it was unlawful to some of the things. The reason this young man was discharged was a trumped up thing that his CO just didn't want any waves. So sometimes there's a price to pay. And a dishonorable discharge is a pretty heavy burden. It's like being a felony conviction. So yeah, sometimes there are hard things, but if everybody in the 151st Airborne group in Utah Air National Guard said, I ain't going, they'd have to figure out someone else to fly the airplanes, I guess. But it's a hard thing. And we as a people have allowed our government to actually, war is the most onerous burden that any nation ever bears. War is institutionalized, legalized mass murder. And it's supposed to be very deliberative and very, you go into it because it's just and has to be done. But we haven't ever done that, in my lifetime anyway. As you point out, all of the different issues that have come up have been adjudicated with us exporting war to nations all over the world. Okay, so unless Congress declares a war, you can't have a war constitutionally, but we do it constantly. We're doing it now with surrogate wars that we've got going on all around the world. Okay, so again, to get convicted of treason, you have to have two witnesses of the same act, and you have to have a confession in open court. The persons that saw it? Oh. Okay, so I'm going to spend a few minutes. Maybe Enoch will end after this particular case. I've covered this before, and we may have some bleed over to next time we get together. If you can hold your breath, we might make it, yeah, you're going to be mighty blue, buddy. Okay. I bring this up because it's a real world situation where people thought they were going to use the Supreme Court as a blunt tool to beat the snot out of the nation. Okay. Nation maybe needed to have the snot beat out of it, but this was the wrong approach. And it's just a sad commentary of what happened and what would have happened had it been successful. We would have lost the republic. We absolutely would not have, I mean, the military tribunal things and all that kind of stuff, anything you can think about, the ruling individuals left in the nation would have been a minimum of 5 Supreme Court justices. Those 5 people would have been fully in charge. And hopefully, as we analyze this thing, you'll be able to say, sure would have been nice to fix this, but this wasn't the right way. Okay, so let's just talk about that for a minute. It was 2023, about a year ago, almost every patriot in the world. I mean, I can't tell you how much review this got in organizations and in news magazines and everything else like that, that I thought probably should have been a little more careful in their analysis, okay? But they were hoping against hope that we could correct the injustices of the November 2020 election. Okay. So it had been before 2 courts. One of them was in Salt Lake City, and the other one had been an appeals court for the 10th Circuit. As you can see, they both happened in 2022, in February and in October. So we roll forward. These things had been, by the way, dismissed, as I point out here, without prejudice, meaning they could bring them up again. They were saying, well, you know what? We don't think you got a case, but if you wanted to keep trying, it's go ahead, have at it. So that's what happened. And everybody, not everybody, but virtually everybody that analyzed this said, see, they think it's got legs. And we're going to put our justice behind this, and it's going to happen. God is with this case. I mean, I heard things unbelievable about this, that God had ordained this to happen. I had some very, very good friends of mine. When I did this analysis with them, they were extremely angry, swore profusely against me and all those kinds of things, because they just didn't want to hear what I had to say. But hopefully you'll give it some listen in your heart, and we can maybe see how this would have been a wrong approach. Okay, so, but at any rate, 2 courts said, go ahead if you want, but we're not going to find any value in this. So it was filed as a potential case to be heard before the United States Supreme Court. Well, the Supreme Court met in January 2023 and says, are we going to review this case in the Supreme Court or not? Is it going to be on our caseload for this year? Okay. I guess we didn't select it. That's what the Supreme Court said. Okay. They're not going to hear it in 2023. Okay, so the Supreme Court rejected the case and set it aside with no further recourse. Supreme Court says we ain't going to do it. Well, when it was rejected, the Brunsons tried another court, and they had a parallel case filed that was with the 10th Circuit Court. 10th Circuit Court is a very apt definition, but most people don't catch the intended humor there. Okay, so they said, okay, we've got a parallel already filed case. We're going to chase it through the 10th Circuit Court, and we're going to take it to the Supreme Court again. Well, this case was also rejected by the Supreme Court. So they were blunted in every case that they went forward on, much to the chagrin of a lot of people that believed in this. Well, what they were trying to do was remove 388 national elected federal officials. Do your numbers. There's 535 people in the Congress, House and Senate. This is the majority of these people, along with some others, okay? So they were getting rid of the national elected officials. They wanted to get rid of almost all the elected Democrats in both House and Senate. They wanted to get rid of a lot of elected Republicans in the House and the Senate. They wanted to get rid of Joe Biden, who had just been through the 2020 election. I won't say he was elected, but he had been through the election. And Kamala Harris and former Vice President Pence. and maybe 100 unnamed Jane and John Does. So they had a pretty wide net that they were throwing out there. It gets deeper. They wanted to apply that 14th Amendment clause about this engaging in the insurrection rebellion, just like it's been played against Donald Trump, and saying, by golly, he can't run, that he can't be on a ballot or anything like that because he did an insurrection. Of course, he hadn't really been charged. He hadn't been gone to court with it, hadn't been convicted, and there was nothing. There was nothing. But they started making these decisions. This case sought to do the thing with 388 elected officials in the United States, out of both the executive and the legislative branch. Okay. They applied some other things about due process and petition and redress. And they wanted to say that their vote on certifying the electoral votes without investigating the potential voter fraud was what demanded them to be removed from office. That was the premise of what they were doing. So they say that because they wouldn't investigate the voter fraud, it was treason. Okay, so they define treason a little bit differently than the Constitution does. Yes, sir.
Those who are the ones who would investigate would say there's no evidence, so therefore they don't investigate. Well,
Yeah. They didn't investigate, so they don't know if there's any evidence, right?
right.
Okay, so, but there was a valid approach to this, and this court case was not the valid approach. So they said the unwillingness to investigate was an act of war. It's a little bit different, and these enemies things start to be applied in a very broad brush kind of thing. They said it was an unprecedented national security violation against the nation and its citizens, so they should be removed from office. Okay, and we'll get into that, how they do really constitutionally get removed from office. It's not through a Supreme Court decision at any time, ever, for any of these people. Okay, so can you violate the Constitution to save the Constitution? The answer is no. It's not a suicide pact that, oh yeah, we're gonna get rid of everybody, and by that we're gonna save the Constitution. No, that isn't how it works. So here's the treason thing. This is by law what was enacted by the Congress, which has the authority to enact a treason law. This is Title 18 U.S. Code Section 2381, in case you want to look it up in your spare time. Okay, so whoever owing allegiance to the United States levies war against them or adheres to their enemies, now by the way, enemies is defined based upon a declaration of war by the Congress, right? Giving them aid and comfort within the United States or elsewhere is guilty of treason and shall suffer death or a 5-year sentence, fined not less than $10,000, and can't hold an office again. Okay, so what they did is they took this section in Title 18 and said, we're applying that to these people and saying they're guilty of treason. Okay, well, it's only been applied 40 times in the history of the whole nation. And they wanted to apply it in one case to 388 elected officials in one Supreme Court action. Okay, it's pretty broad brush. Again, we're going to take them all out and hang them. I mean, I guess if you decide that's what you're going to do, let's do this one court case and we can hang them all. I mean, that's kind of what they were asking for. Can you see how this thing starts to violate the premise of American jurisprudence and the idea of due process and these things that we hang our hats on? And we have to, unless we want to go to that military tribunal thing where, I mean, when I was in the service, they had what they called, and they still do, the Uniform Code of Military Justice. It's uniform and it's a code, but there's not much justice in it, from my experience. I never was accused or convicted of anything, so I don't have an axe to grind in that manner. But the fact of the matter is, I have not seen it to be something that I was comfortable with most of the time. Okay, so this levying war against the United States is defined as taking up arms against the United States to overthrow the government. Were there any arms involved in this thing? Anyway, I don't think there was. Prevent it from carrying out its lawful functions, okay? It's one of those things that gets pretty thin. So adhering to the enemies of the United States includes, under code, providing financial support to a country that is at war with the United States. Didn't happen. Giving sensitive information to a country that is at war with the United States. See, these kind of things they're defined in statute federal statute says blah, blah, blah. Okay, I don't need to review all of it again, but you understand.
Then why were there several people who were tried and executed for treason and sold sensitive information to the Soviet Union during the Cold War? There was not a declaration of war.
They provide sensitive information to the country, okay? Okay, the question was, why were some people, the Rosenthals, I'm pretty sure you might be referring to,
And Hanson and a couple of others.
there were a few people that had this situation go, and that was part of the big Red Scare, and they did execute him. And I think probably it was done unjustly. But the fact of the matter is, that's what was carried out in it, and they were against 2 people or 4 people or however many there were. And why did we torture people with all of the things on the Gitmo and all that kind of stuff? It was done unjustly, okay? But the fact of the matter is, an injustice does not justify what codes go against the code. Okay, so to be convicted of treason, you have to commit one of these acts with, now this is underlined and emphasized, specific intent to betray the United States. It must have been intended. It couldn't be that this is a subsequent outcome of what you did. You did it purposefully to betray your nation. That's a big argument too. Treason has only been ruled by the courts as possible when an action is carried out during a constitutionally declared war. That's where the Supreme Court has been ruling. Okay, so there's some other pertinent constitutional issues, and hopefully in the next few minutes we'll finish these and then we'll take them up next time. Yes, sir.
There are nations.
Go ahead. No, go ahead.
There are nations who say that they want to take over the United States
Yeah.
without firing a shot. So by definition, it's not war, but the result would be the same.
That's why we need to get, okay, so the idea is there are nations that are trying to take over the nation. Okay, right now, and this is a side trip, our president is guilty of violating his oath of office to carry out the laws of the nation. Congress has established laws of the nation, and those laws have to do with immigration, naturalization. They have a certain specific process you go through to come into this country, okay? And so the president is allowing people to come in, millions of people, D-Day invasions every 2 or 3 weeks, okay? And we have thousands of military-age young men, single men coming into this country. We probably have 50,000 people in from China. Oh, thank you very much. We have 50,000 Chinese in here right now, for example. Let's just say for a moment that those 50,000 Chinese are distributed into the 50 states evenly, and so that means 1,000 per state. And let's just say that they're a sleeper cell that's when they get the order, they carry out certain actions against the United States. How long would it take 1,000 dedicated, trained people with the proper equipment to overwhelm the local authorities? About a nanosecond, okay? So, while we don't have a declared war, we do have constitutionally mandated and oaths taken by the executive to prevent these invasions, and that's justification for impeachment and then ultimately removal from office. Okay, so there's a process that it goes through. And so there's a system that we use, and it works good, but we've got to have Congress with a backbone. The House has to be willing to impeach. The Senate has to be willing to remove. And then we got another problem. Kamala's going to take the job. And there's another problem if she gets removed, and it's Mike Johnson. Anyway, the point of the matter is I'm not happy with a lot of our choices right now. And we, the people, are responsible for putting the people in there that we have. It's taken decades to get there. And we're not going to fix it in days. It's going to take a while for us to win this back. We need more friends than we've got. So here's a few constitutional considerations that I believe are pertinent. First of all, the House has the sole power of impeachment. That is how we remove an executive from office, through impeachment process that then must be followed on by the Senate trying that impeachment. So the House brings charges, the Senate then carries its duty forward and decides to remove from office. And if they get 2/3 of them, which is virtually impossible now, as you watch what the clowns did at the last night's fiasco of a pep rally that they ran called a State of the Union. So the president is tried, the chief justice presides, and they are removed with 2/3. You have to have 67 senators. Okay, so that's the process by which you remove a president.
So the ones that Brunson wanted out would have to be taken out by the ones that Brunson wanted out.
No, not necessarily. The ones that Brunson wanted out would have to be taken out by an impeachment process. You're going to find that it's even more complicated than that. You're going to find that what he wanted to take out, what they wanted, their brothers, wanted to take out in the executive branch, you have to have them impeached and then removed.
Right.
But it's even more complex than that.
Congress, too.
The Congress removes itself if you have just people. It sounds pretty hopeless, but we, the people, are responsible for putting the fools in there we currently have. And we say, well, we got to get rid of the turkeys. Well, yeah, we got a ballot box, but we won't do it. I mean, you know what?
Well, right now we have some new Republican state delegates. Talk to them. They'll be very responsive.
Your Republican state delegates, Democrat state delegates, independent state delegates, talk to everybody. The Republicans are not salvation. They are a smokescreen most of the time.
Right.
So it is not just a Republican Democrat thing. We have to get people of quality, people with character, people with principles. And unless until we do that, we're still stuck with the same yo-yos we've got.
So we fight the corruption from within the Republican Party.
If you can, but if you're Democrats or, let me just say this about that real quickly. Okay, you're saying use Republicans to fight that corruption. Most of the time, if we are successful in stopping an effort within a state to not have a Constitution Convention call, it's with the help of the Democrats. Almost no case do you find that we win that battle without the help of the Democrats. So we need friends from all sorts of places and in the most unlikely places. And I'll take their support to do good things. So I'm not going to stop it. Okay, so here we have from Article 1 again, this is the legislature's job description. They have impeachment and conviction, they remove them from office, and then they can go to indictment and trial. Criminal charges can be done. Go read your Article 1, Section 3, Clause 7. Okay, so here we go back to Article 1, Section 5. Each house gets the determination of its proceedings, and with the concurrence of 2/3, they can remove a member. But who's George Santos? Anybody hear him? He's a Republican that was just removed from office by 2/3 of the House that said he's unworthy to be in this office. It can be done. And that's how you get people out of the House, if you can't vote them out. But every 2 years, you get a chance to vote. Okay, so senators, and I'm not going to spend a lot of time on this because we really are out of time, but they cannot be called into question in other places because they're protected by Article 1, Section 6, Clause 1. And this was put in effect for good purpose. The king used to say, you know what, those turkeys, the Parliament, I can't get them all on my side. And so he'd arrest them when they were going to vote, or he'd arrest them when they were leaving. Throw them in the slammer, and then tell he had a majority, and then he'd win. But they says, no, we're not going to let the executive bully the House and the Senate. So they said, in all cases except treason, felony, and breach of peace, these people that are in the House and the Senate are privileged from arrest at the session, going to and from their houses, returning for any speech, debate in either house. They shall not be questioned in any other place. That was to prevent what the king had been doing to his parliament. So they are protected, and they have and there's good reason for it, but we've got to get good people in there that will impeach the people they can, that will work on removing the George Santoses from office. And every 2 years, we get a chance to get rid of all of our House, and we get rid of 1/3 of the Senate, and every 4 years, we can cleanse the executive branch. Spineless Republicans is why Biden has not been impeached. That's the only answer I can give. They're just nibbling around the edges. They're waving their arms, and they're not doing anything. That's an absolute travesty what they're going through. He violates the Article 2 responsibility to carry out the laws. He's not doing it. Congress created the laws. He has to carry them out, and they're not doing it. And he needs to say, they're nibbling around. Monica Lewinsky was another thing. Sexual impropriety is easily understood, and it's kind of tawdry and tantalizing and all this kind of stuff, but they should have gone after him for other reasons, and we could go into that at great length if we wanted. But it's the same thing with Hunter Biden. They can go after tawdry other things, including bribery and all that kind of stuff, which is kind of a proportion of that. But he's doing other things that are a violation of the Constitution. We need to have people go about that. Okay, so let's go on here quickly. The president, vice president, civil officers shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Have you seen anything in here yet that says the Supreme Court can remove people from office? Have you been watching and listening carefully? Okay, that is a critical key point. At no point do they say, oh, just in case, the Supreme Court can kick you all out. There's nothing of that. Supreme Court doesn't have any power to do what the case demanded. Okay, so what should they have done? This is what they should have done. This is out of Article 3, Section 2, Clause 2. This is the section we're reading. It says judicial power shall extend to controversies between two or more states. So let's say Texas filed a suit against another state for the idea that, they had improprieties in their voting. Okay. And here's going on with it in Article 3, Section 2, Clause 2. In all cases affecting those in which the state shall be a party, the Supreme Court shall have original jurisdiction. So when those suits were filed, the Supreme Court had a responsibility, a duty, an opportunity, whatever you want to call it, to step in and say, hold it, Jackson. It wouldn't be, maybe use that name, but hold it for a minute. Here's two states that are at odds with each other. That's our original jurisdiction. So what they should have immediately done when the states filed their voter fraud cases against these other states, they should have immediately taken up the cases and reviewed them. At that point, the Supreme Court had jurisdiction to look at it before there was a seating of any of the people. It's just like George Santos. The Republicans knew this guy was a yo-yo out of New York, 3rd District, I think. And what happened was they so desperately wanted a Republican majority that they blinked their eyes, closed their eyes, covered their ears, whatever they had to do, said, we'll take this guy. He's got an R behind his name. And they knew that the guy was not a straight-up fellow. And they let him in anyway because they wanted the majority. They found him to be a real detriment to the operation that would happen in the House. So they couldn't just say, after they had seated him and sworn him in, they couldn't just say, you're out of here. They had to get 2/3 of the House to agree. There are processes that are in place that you cannot wave a magic wand and say, suddenly the Supreme Court can kick everybody out of office, okay? They could have done it when they could have done it, but not after, when Brunson's wanted it, okay? Okay, so this treason thing, it's only levying war, adhering to the enemies, giving them aid or comfort. You can't convict of treason unless there's 2 witnesses to the same act or in confession in open court. None of those happened. None of these conditions were met in the demands that Brunson's wanted in their Supreme Court case. And if it had been carried out, it would have been a comprehensive, unequivocal usurpation of all power within the United States. If they could have got 5 Supreme Court justices to agree with them and 4 against them, it would have said those 5 completely overthrew the legislative body. They expunged the executive branch. How about that, sports fans? These 5 people can rule and reign in a house of horror. Okay, so here's what happened. Okay, we'll end. It's after our time by a few minutes. I'm not nearly as bad as I thought I would be, but I'm twice as bad as I really am, because we're going to have to carry out this again later. And we'll carry it into what we do next time. Well, I'm going to have to remember which slide we're on. I've taken an hour and a half of your time, and we've tried to do this, but we have to kind of unpeel the onion a little bit. But the United States Constitution divided and subdivided power. It was co-equal between the different organizations. There is not a supreme organization that takes precedence over anybody. Read the Constitution carefully between now and next time we come, and tell me where you find a supreme deal. Everybody takes an oath of office. Doesn't matter if it's a congressman, a senator, a judge, a president, a dog catcher. I mean, everybody takes an oath of office to uphold Constitution of the United States, and if they're in our state, they do their Constitution too. They all have separate responsibilities. And just like in the COVID con that happened for over the last 4 years, Utah Constitution, for example, says specifically, it doesn't matter if there's an emergency. The executive cannot legislate. It violates the separation of powers. It's specific about even emergencies. But a few years ago, the legislature said, hey guys, if there's an emergency, we're going to let the executive legislate. It was unconstitutional, and they and he should have been removed from office, unquestionably. So nobody can say, I'm the king for a day. Nobody can say, I'm the monarch. We think we elect presidents that act like monarchs, and they shouldn't. So next time we get together, we're going to talk about what the Founding Fathers said about separation of powers, and then we're going to get into Article 4, and hopefully I can do those two things in one session. But we'll see what happens. So I thank you for being here, and maybe, Enoch, if you have a microphone you want to pass around, or maybe everybody's asked all the questions they want to.
Okay, test. There we go. Okay, so I think we'll wrap up, and I'll just make some closing comments, I think, and then dismiss, just because we're running late on time, and we try to be consistent so that we're predictable, so that people want to come back. Right? I learned that from the John Birch Society.
And I will sit down now, if that's okay, so you can.
Yeah. Thank you, Scott.
Well, thanks to you guys.
Yeah, we appreciate these deep dive discussions, and picking apart the words that like we're doing is so important, because you kind of saw the questions that came up. It's like, well, that's not how they're doing it, or you know, all these things that we pick up from culture, from TV, from news, and even just from people around us. It's these are things we have to unlearn and unwind. And once you understand them, you can't. It's like you see something, you can't unsee it. Now you get it, right? Things are clear. These are imperative truths we can observe as to how this is supposed to function. And so, so some of the conversation about, like, you know, Republicans can fix this, right? Or we're gonna have a new sea of delegates. So Defending Utah started in 2013. And we've been through many seasons of many of our members becoming delegates, and many of them running for offices in you know, various parties, and you know, the shenanigans that happen over and over. And we take the position that our problem is not the Democrats or the Republicans or even certain politicians. We have a root problem. And it's what the Founding Fathers called combinations, okay? And it's what the Book of Mormon calls secret combinations, ultimately. The John Birch Society talked about this same thing. They said, we have a problem in our politics, and it is a worldwide communist conspiracy, is what they identified initially in the 60s. And then through their many years of work, they identified communism is not the root of this problem. Communism is an extension. And there was a book that came out. There were several books. Tragedy and Hope was a main one. None Dare Call It Conspiracy. And on top of a first book that was released called The Naked Communist, then there was The Naked Capitalist. Who's funding the communists? And so understanding the root cause and knowing our enemy and knowing ourselves. This is a lot of what on our website. We have the Liberty Bootcamp that kind of goes through those basics. We have the book Utah's Secret Combination, which was trying to unwind the shadows of power in the state of Utah. And I'll advocate to stand and do good anywhere you can. sure, work in the parties, work in, wherever you feel in a moment, but you have to understand the big picture. You can't get focused on something, and they're very good at distracting us and wasting our time. And so that's another thing that we talk about in our books and in our trainings. And so we would invite you to look at some of that stuff online and get caught up on that, and then identify what we're proposing as the solution today. After a decade of fighting and seeing voter fraud and shenanigans behind the scenes and hoping Republicans would do something and realizing they won't, and then having the next guy, well, maybe this guy, and even the best guys just stay out of the battle, and they won't do the hard things. Many solutions we brought to what we thought were the best legislators on our side. And when they saw, oh, that's a real bill, that's actually going to do something, I can't touch that, right? No one would vote for my bill, or, okay, you're right. It was politically dangerous. They won't do the things that are necessary. And so we also try not to be distracted on the national too much, although it's entertaining and it's fine. And we're studying the Constitution, which is national. It's all important, the principles that are there. But then we're trying to take that constitutional knowledge, say, how do we nullify, how do the people get the Constitution to a place of honor right where we live in our communities? And so the solution we propose, there's a short link on our website, defendingutah.org/committees. And we have the book here that is the map to apply these principles to defend the Constitution. But if you guys want it, you can go to our website. On the contact page, I'll send you a digital copy for free. Just want to get the information out. There's some overlap in what we're talking about with solutions that you see out there. A lot of people doing, there's a lot of solutions out there, and I would say they're a mixed bag. They're half principled, but then half not. There was this exciting video that came out the last couple of weeks. These people running into a Maricopa County meeting, you guys may have seen it, and throwing these papers down to the, what was it, a school board or a county? Do you remember? Something like that, right? I think it was a county. Maricopa County, right? And just demanding, we the people demand you do what we say. This is such an unprincipled approach, and the way they're doing it is looks a lot more like a communist agitator than a group of educated, intelligent citizens who understand the law and are doing their best to educate their local government officials. And then, sure, there's things you can take beyond that if they won't listen to it, right? But that's where we talk about the big picture, and my book tries to address some of that, how the people have to build centers of power. So our motto here says, think right and wrong, not right and left. And that comes from us realizing we get sold out when we focus on parties, right? And of course, the Republicans talk about the Constitution much more, but some of our experience in the talk, right? They did a lot of talk. But our experience also shows even Democrats will get behind the Constitution sometimes when you're dealing with real people with real issues, and it's not the media rhetoric. The John Birch Society actually worked with Democrats in the state of Arizona to get nullification of the Real ID passed back in maybe it's 2010s or early among that time. And the Democrats got behind them because they like their freedom of speech and so there's alignment on principles when we forget the parties and we just think about principles. Okay, so we're going to wrap up for tonight. Thanks for everyone online. Yeah, you have a question? Yes, okay, so the meetings here, thanks for asking. Yeah, are once a month. And on our website, we announce it and we send out the email on our mailing list. But it would be April 5th. Okay. So the way that works is we kind of take the first Monday through Friday of the month, and we have 3 meetings every month. We have a Monday meeting online, which is for people who sign up as members of Defending Utah, and we talk about Utah-specific politics. And then Tuesday night, our national counterpart, the American Committees Association, we do a national meeting, and that's for people that are taking that manual and trying to actually apply the principles of committees of safety as the founders showed us. And we have friends in Canada, friends in various places in California and in Michigan. I spoke at the Red Pill Expo in Ohio, right, and got a lot of contacts. So we're trying to take what we've learned in Utah in the trenches and apply it nationally. And it was specifically endorsed by G. Edward Griffin, author of Creature from Jekyll Island. That video is on our website. Of course, it's one of my favorite now. He says, I wished I would have been reading this a long time ago. I would have saved a lot of time. And so that was fun. So we do those meetings once a month, that first Monday through Friday. So yeah, thank you for asking. And the registration page is always the same, Bootcamp Monthly. And we just hope we can build the knowledge in our communities of the Constitution and start learning how to apply it practically. And that's about it. And so thanks everyone for coming, and have a good night. We'll see you next time.